Good morning, good evening, good afternoon. I want to talk about this little video that Jeff Gray does. I hope that none of my audience believes that I dislike Jeff Gray. I do enjoy Jeff Gray's videos. I don't always agree with Jeff Gray's analysis. Sometimes it hurts when he starts talking about, hey, I'm telling you that that I have a right to do this, and if you persist, you're going to lose your qualified immunity. It shows that he doesn't really understand exactly what he's talking about. But at the end of the day, I like Jeff Gray. I really like Jeff Gray. I love the way he audits. I love the way he comports himself. I like that he doesn't get all up in people's faces, and he is literally just engaging in speech. Now, another thing that I disagree with him on is his understanding that all sidewalks on city property are somehow traditional public forums. There is a test that goes into place. But that's not here or there. So I just wanted it to be very clear. I like Jeff Gray. Jeff Gray, open invitation still stands. If you're ever in California, Northern California specifically, let me know. I'll take you out to steak dinner. I'll pay, and we go out and we could stand around with cardboard signs that say something along the lines of "Pray for homeless vets." I have no problem with that. I would love to do it. You seem like a nice guy. Wouldn't mind hanging out with you. And I'm not hitting on you unless you want me to be hitting on you, in which case, sure, why not? Anyway, in this case, I didn't get that far into it. I started watching it this morning. It looks like officers have someone. This gal right here is in a security guard uniform. So, and they're trying to get her to roll up her window to show her window tint so that she can so the officer can determine whether or not she's in violation of Florida's window tinting statutes. Now, the window tinting statute that would be violated would be the section 2953 and chapter 316, the Uniform State Control. This talks about how the side windows have to have 25% on the non-film side and 28% on the film side or something like that. I'm not entirely sure. Don't really care. What he is saying in here, I don't know why he's suggesting this. He's saying it's a non-criminal traffic infraction. You could still get pulled over. The state can still enforce it. The Florida Highway Patrol, the division of the Florida Highway Patrol of the Department of Highway Safety and Motor Vehicles can enforce it on the streets and highways thereof and elsewhere throughout the state wherever the public has a right to travel by motor vehicle. Counties, the sheriffs, again, they have the right to enforce it on any private or limited access road over which the county has jurisdiction pursuant to a written agreement, as well as anywhere in the county the public has a right to travel by motor vehicle. So what this specifically does is it allows the county to enforce it on a private parking lot. And then finally, the cities, the municipalities, the police departments, they can also do it. So it is a traffic infraction that is enforceable. The cops can pull you over for it. So I don't know why he doesn't. But then we have where are we going? This, right? So then this was what really oh, you're not seeing any of this. You're not seeing this. So this was the thing that kind of set me off. The Fifth Amendment's right against self-protection protects people from being forced to reveal to the police, a judge, or any other government agents any information that might subject them to criminal prosecution. And it doesn't necessarily do that. The Fifth Amendment protects you against communications. They can't force you to say anything incriminating. They may they may be able to require you to say like a specific word, like they may give you a something to read that you have to read out loud. They may do that. That might be something, but rolling up your window to the extent that would allow the officers to test the window to see whether or not it violates the window tinting laws is not something that's protected by the Fifth Amendment. So where did he get this? Oh, and by the way, I just want everybody to understand that I don't give a shit about window tinting laws. I think window tinting laws are pretty much bullshit. My windows aren't tinted, but I don't really give a fuck if you want to have your windows tinted. I don't think it's a safety issue. I understand that police officers think it's a safety issue because they can't see you when they pull you over and you might have a gun. And I don't give a fuck about that level of officer safety. I don't know why we have to lose so many of our freedoms in the name of officer safety. So I want to be very clear about that. I am not arguing in favor of window tinting laws. Are we really live? No, we're not live. We're not live. This is a pre-recording. So where did he get this? And why does this upset me? Well, I found out where he got it. This is where he got it. I don't want to scroll up, but I will. This is academia.edu. And while I'm down here, we'll just go over, we'll just make sure we'll inspect what we expect, right? The Fifth Amendment's right against self-incriminating the Fifth Amendment's right against self-incrimination protects people from blah, blah, blah. And then it goes on, even if a person is guilty of a crime, right? Then Fifth Amendment's right against self-incrimination protects people from blah, 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 even if a person is guilty of a crime. So you can see that this is the only place that has this particular language, right? Hey, Paige, how about you shut the fuck up until I'm done? Let me get through the presentation, and then maybe you could ask your stupid ass questions. You still haven't shown me all the tits that you owe me. So in the meantime, shut the fuck up, sit back, stop getting ahead of me, and listen to what I'm saying. Okay. Can you do that for me? Maybe you'll learn something if you just shut the fuck up and listen. All right. So this is where he gets it from. Now, so the issue here is that if he continued to read, this is the bottom of the paragraph that he was quoting from. This right is limited to speaking, nodding, or writing. In other words, you can't be compelled to communicate information. You can't be forced to testify. You can't be forced to say yes or no. You can't be forced to write some communication, specifically communication. Other personal information that may be incriminating, such as blood or hair samples, DNA samples, or fingerprints, may be used as evidence with or without the accused's permission. So he already cut out this very crucial portion of this particular writing. Now this particular writing is the Constitution by Donald A. Ritchie and the Justice Learning Org. This Donald A. Ritchie is a historian. He was, I think, the White House historian or I don't remember exactly, but he's a historian. He's not an attorney. But as stated in the complete paragraph, his summation is a perfectly acceptable summation of the Fifth Amendment right against self-incrimination, which is something that Jeff Gray has, I don't want to say purposefully let out, but it makes me wonder, like Mr. Gray, what are we doing here, sir? Are we misleading people? Is this intentional or unintentional? But to go further to maybe perchance help stupid people with lovely tits like Paige, this case and this case are two United States Supreme Court cases. You'll see that they're fairly old. They're from the 60s, 1966 and 1967. Because remember, any amendment has to be, any of the first amendments have to be incorporated into the 14th Amendment in order to be usable against the states, right? So in Schmerber versus California, you have this lovely little line. They're looking in Schmerber versus California. They took a drug or a blood sample from someone in order to be able to prove drunk driving. And the question was that violating the right against self-incrimination? Okay. And so in Schmerber, the court says it's clear that the protection of the privilege, meaning the privilege against self-incrimination, reaches an accused's communications. That's an important word, whatever form they might take, and the compulsion of responses, which are also communications. The compulsion of responses that are also communications. For example, compliance with a subpoena to produce one's papers. Your papers are going to have communications on them. On the other hand, both federal and state courts have usually held that it offers no protection against compulsion to submit to fingerprinting, photographing, or measurements, or to write or speak for identification, to appear in court, to stand, to assume a stance, to walk, or to make a particular gesture. The distinction which has emerged, often expressed in different ways, is that the privilege is a bar against compelling communications or testimony, but that communication which makes a suspect or accused a source of real or physical evidence does not violate it. In other words, yes, the officer can order you to roll up your window so he can test the window. There is no problem with that. Similarly, in Gilbert versus California, this is where they had the accused write down things in one case, and then it was used against him in another case. The exemplars they're talking about are writing exemplars, where they're looking at the way his writings look, how his handwriting looks. So it says the taking of exemplars, written exemplars, did not violate the petitioner's Fifth Amendment privilege against self-incrimination. So they forced him to write stuff down. Paige, did I answer your question, Paige? The privilege only reaches compulsion of an accused's communications, whatever form they might take, and the compulsion of responses, which are also communications. For example, compliance with a subpoena to produce one's papers, and not a compulsion which makes the suspect or accused a source of real or physical evidence. One's voice and handwriting are, of course, means of communication. It by no means follows, however, that every communication or every compulsion of an accused to use his voice or write compels communication within the cover of the privilege. A mere handwriting exemplar, in contrast to the content that is written, like the voice or body itself, is an identifying physical characteristic outside its protection. What don't you understand, Paige? What don't you understand? This is the part where you can ask a question. And instead of, and before you say something like, doesn't this violate the accused's right against assisting in the investigation? Why don't you show me a fucking statute that says that they can't be forced to, I don't know, put on gloves, a la what's his name, the football player. If the glove doesn't fit, you must acquit. O.J. Simpson. O.J. Simpson was required. So like people can't wait. Why are you saying that people can't be forced to give their passcodes? They absolutely can. Where are you getting this from, Paige? Did you pull this out of your ass? And can I watch you pull it out of your ass? What law do you think protects people from being forced to give their phone passcodes? If the government gets a subpoena or a warrant to get into the phone and you refuse to comply with it, you could be held in contempt. You could be held in civil contempt, i.e., the government can jail you until you turn it over. Well, maybe Massachusetts has some law that I'm unaware of that gives more protection than the Fourth Amendment. But under the Fourth Amendment, the government can, because remember, let's look at the Fourth Amendment. Let's fucking help a sister out. All right. So this is the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue, but upon probable cause. So if you have documents in your phone protected by a passcode, there is no difference between that, a warrant to get into that, and a warrant to get into your safe, where you have a dial or a passcode to get into your safe. There's zero fucking difference. Zero difference. Yeah. Yeah. I mean, despite all the fucking evidence that shows that, yes, the court can do this. Yeah. Page still believes, because some David Yannetti attorney in Massachusetts said something that she wanted to be true and misinterpreted. Yeah. Yeah. It literally fucking happens. Bend over. I'll teach you. It literally happens. So, yes. So you can't be compelled to give your passcode unless and until the court gets a warrant, or the police get a warrant. Once they have a warrant, you have to give up the passcode. Well, so there's a huge difference. I don't know if they can search your phones and computers, like the contents of those, but there's a huge difference between the level of protection that you have within 100 miles of the border and the level of protection you have outside of that 100-mile barrier zone. And I totally 100% disagree with the 100 miles border, which I think is stupid. Yeah. No, it's the court says some shit like, the powers of the government to do shit are at its zenith at the border, because the government has the right to protect the border. The federal government has the right to control what goes across the border. And so the Supreme Court basically just designed a 100-mile zone around the border, which, by the way, just so everybody is aware, captures most of the population of the United States. Most of the population of the United States lives within 100 miles of a border. And you're going to say, well, I live in San Francisco. I live a long way from either border. Well, no, there's also a border, which is the coastline. So basically 100 miles in from the coastline, all the way around the coasts, the East Coast and the West Coast and the Gulf Coast and the coasts of the Great Lakes and things like that. 100 miles. Well, actually, no, those wouldn't be, because there's a line in the middle of them. But basically 100 miles. Well, you're more or less 100 miles from Canada at that point anyway. But yeah, it's most of the United States has reduced powers of the Fourth Amendment. Well, lucky for you, we can't all be so lucky. So anyway, that's that. So again, my issue is that, first of all, Jeff Gray didn't realize that rolling up the window does not, or being forced to roll up the window is not a Fifth Amendment violation. I'm surprised that he doesn't know that. Why do you think I haven't taken care of the chickens? Why do you think that, Aaron? Are you upset? Are you upset that I'm dropping knowledge bombs? And that's all you got is go take care of your chickens and shit? Huh, that's sad. So that's my disappointment with Jeff Gray. Again, I like Jeff Gray. Jeff Gray, my offer to buy you a steak whenever you come out to Northern California, it still stands. I am disappointed that you would do this, and I hope it was a mistake and not intentional. So then there's Michael Eline, and I just want to be very clear that I don't watch Michael Eline's content. I mean, there's a few cases that people have bribed me to watch, but I don't watch his content. I don't like his content. He doesn't offer anything of value. He spends his time making slides that are either misstating the law or don't cite to the law. So you can see I don't fucking watch his shit. I don't care about his shit normally. He's a retard. Like I think I have made it very clear that Eline is fucking retarded. And you might also notice Eline hasn't sued me for defamation. And if he does sue me for defamation, he knows or should know that he's going to lose because he's fucking retarded. And I'm not. And that's the difference between him and me, is that he's fucking retarded and I'm not. But he has this one right here, suing a state court judge for federal civil rights violations, right? And I have not watched it. And so I just want to be clear what I'm responding to. I'm responding to Boy 1982, who has a huge boner for Eline, who likes to watch Eline. I don't fucking care. But apparently he's accusing me of using sock accounts. Michael, I don't use sock accounts. I have never used sock accounts. I don't use sock accounts. I try to be very respectful if I do go on anybody else's channel, with the exception of F3. Their channel is more of a shit talking channel, so I'm much more prone to talk shit there. But Josh and Jeff both know that I like them, and I don't think they take any exception to me. So he was talking about judicial immunity. And so I said, or he was talking about suing the government. So I said, obviously, that I'm sure he arrived at judicial immunity immediately, because judicial immunity is 100% going to bar Chile from suing this judge for damages. 100%. And it's also going to probably stop him from suing for anything in the future to suggest that she has violated his rights going forward. And that one decision that she made, I guess in theory, he could get a decision from a declaratory decision from a federal court that her decision somehow violated his rights. But the odds against that are somewhat slim. Socks with sandals should be a crime. I'm all in favor of freedom, but I'm not in favor of the socks with sandals kind of freedom. So he said. So Boy says he danced around it for 1.5 hours. He just said it would be tough for Chile. Is that? I just wonder. Is that like giving odds? Is that saying that it's possible for Chile to do it, but unlikely? Is that giving odds? Is that how giving odds works, Michael Eline? Said criminal charges against her would be easier if they have a sympathetic prosecutor. And this is his slide, apparently. This is his slide. Now, why is this fucking laughable? This is fucking laughable because of Screws versus the United States and the method by which the Supreme Court interpreted 18 U.S.C. 242 in order to make it constitutional. So you have a right. Anybody in the U.S. has a right to basically be informed of what the law is. A law has to be written in such a way that it's not unconstitutionally vague or unconstitutionally overbroad. And you know what? We can pull up the text of 18 U.S.C. 242. And just so everybody's aware, 18 U.S.C. 241 has similarly been defunct. So 18 U.S.C. 241 is the conspiracy to commit a violation of rights under color of law, and 18 U.S.C. 242 is the actual deprivation of rights under color of law. So there's three basic things that the prosecution has to prove. They have to prove, number one, that whatever you did was willfully. Number two, that whatever you did was a deprivation of rights, any of the rights secured by the Constitution or the laws of the United States. And why am I drawing a blank on the third one? There's three. What's the third one? Why am I drawing a blank? Elements 18 USC 242. I don't know why I'm drawing a blank. Oh, they have to act under color of law. Duh. All right. So the color of law part is the part that I was missing. So basically, they have to be like a cop, somebody acting under state or federal law, or county or municipal law, but they have to be acting under color of law. They have to willfully violate a right that's protected by the Constitution or federal law. And so the problem is that violating a right under the Constitution is very fucking nebulous. Like, how do you know when you've done it? And you can see in 18 USC 19 or 42 USC 1983, this lawsuit for deprivation of rights under color of law is that they have qualified immunity because police officers who generally get sued by this stuff won't know necessarily that what they're doing is a violation of the Constitution unless and until there's been some ruling by some court that says, yes, actually what you're doing is a violation of the Constitution. It's really hard. I'm trying to keep myself from rocking back and forth because I watched a video of Robert Barnes rocking back and forth while he was being the typical Robert Barnes douchebag. And, fat men shouldn't rock back and forth. There's this other guy, real fat guy who streams with Andy Worski, Kino Casino. I forget his name. Fat, disgusting dude. And he always rocks back and forth. Anyway, rocking back and forth is bad. So I'm going to try not to rock back and forth. Anyway. When you're looking at 42 USC 1983, you can see that in order for you to be able to sue the cop, in order for qualified immunity not to apply, the right has to be clearly established. And it's basically the same thing with 18 USC 242. The right has to be clearly established. So Screws is the Supreme Court case that talked about it. I limited my search of cases that dealt subsequently with these same provisions. The willful provision is a big one, but also it's the clearly established part that is important. And I found U.S. versus Reese. This is a Ninth Circuit case. Again, we're looking at cases that would be precedent in Nevada, which is Ninth Circuit. So I looked at the Ninth Circuit and I looked at the District of Nevada, which is most likely going to be very persuasive. But this is U.S. versus Reese, and they're talking about how the Screws Court did it. They're using Screws. They're basically explaining Screws, which is a lot easier than reading Screws, which is a long-winded conversation that really you could only get a lot of information out of if you studied it and you were an attorney. So the U.S. versus Reese kind of provides you a synopsis. It says the court nevertheless turned back the defendant's challenge. It did so by construing Section 242's reference to willfulness as requiring proof of specific intent in order to sustain a conviction for federal civil rights violations. Specific intent, according to Screws, is an intent to deprive a person of a right which has been made specific. So it has to be a right that has been made specific, either by the express terms of the Constitution or by the laws of the United States or by the decisions interpreting them. So if it's a United States law, that would be specific. If it's an express term of the Constitution, then it would be specific, or a decision that's interpreted them. And before you go on and tell me that Chile's case violated, the judgment in Chile's case violated the express terms of the First Amendment, you're wrong. It didn't. It was a debatable question, which is why I gave the odds that I gave. And in reality, I gave the odds that I gave because there was a factual determination that the court could have made that the officer was responding to Chile's presence, his proximity, and not his speech. There was also a very valid argument that the officer was responding to the speech because, again, both Chile's brief and the state's brief acknowledged that the officer did not react. He didn't have an issue until Chile started talking to the driver. So the intent, there has to be an intent to deprive a person of a right that has been made specific, either by the express terms of the Constitution or the laws and decisions of the United States interpreting them. The court explained that so construed Section 242 would authorize punishment only for an act knowingly done with the purpose of doing that which the statute prohibits, so that the accused cannot be said to suffer from a lack of warning or knowledge that the act he does in violation of the law. And there's also another provision that's much like the actual malice provision. I'm not going to continue to go into it, but if you remember, the actual malice provision for defamation laws means that the speaker has to either say something that they know is false or act with reckless disregard as to whether it's true or false. And that means that they have to either know it's false or they should have known it was false. And they chose basically not to look. That's kind of the same standard. The officer or whoever's violating 18 USC 242 doesn't have to be thinking, I'm going to violate your constitutional rights. But if the officer should have known what he was doing was violating your civil rights, then it's most likely prohibited. But essentially what it's done is it's created a thing called a fair warning doctrine. You have to, the person who's being charged with 18 USC 242 must have had fair warning that their actions are unconstitutional, or that they're violating your constitutional rights. There has to be fair warning that some other court somewhere has looked at this and said, yeah, or it's just so blatant on its face that it's, yeah, I mean, you're definitely violating their constitutional rights. There's just no way around it. So the problem is, for trying to get a prosecutor, and it would be an assistant U.S. attorney, because this is a federal charge. So this must be brought in a federal district court, and it must be brought by the assistant U.S. attorney, the AUSA, or the actual U.S. attorney, but that guy's not going to come down for it. So it's going to be an assistant U.S. attorney who would have to bring it. But the problem is that you would not, the AUSA would not be able to meet the burden of proof to show beyond a reasonable doubt that this judge knew or should have known that she was depriving Chile of his rights in deprivation, or in, against unconstitutionally violating his rights, is what I should say. And it stands to reason, like, if you fucking think about it. First of all, I believe that Eline allegedly thought that the judges and prosecution are both part of the government, the good old boy network. This is really fucking stupid. It's a stupid argument to make, because this would be a federal prosecutor, the AUSA, and a justice court state judge, a very low level judge in the state, and a AUSA. The odds of an AUSA being in front of that state court judge, that justice court judge, are somewhere in the slim to none range. Somewhere in the slim to none range. If an action is brought against the U.S. in that justice court, which I don't think it ever even could be on jurisdictional grounds, it would be dismissed. But let's say it was brought there, and an AUSA would make an appearance to remove it to federal court or something along those lines. It's one of those situations where there's just the odds of there ever having been any interaction between Judge Zimmerman and an AUSA in a professional courtroom environment, or even outside of court, somewhere in the very low range. I mean, maybe the Eline group can come to, like, they could do some digging and find out that she actually went to law school with someone who turned out to be an AUSA or something like that, and they could point to that as the reason why charges aren't brought. But my point was, show me one case where a judge was tried specifically for reaching a judgment under 18 USC 242, specifically for a judgment they now I have seen cases where judges have been charged under 18 USC 242 for actions taken while being a judge. Like for I think there was one guy, a pretty big case, where he sexually assaulted like the gals who were working for him as clerks or something, and he did it while he was a judge, and he was charged under 18 USC 242. But I think that actually made it to the United States Supreme Court. Lanier? I want to say Lanier. Lanier. It was Lanier. And I don't know whatever happened to him. It was vacated and remanded. So this guy was a judge, a state judge somewhere. He was a state judge, and he sexually assaulted his staff. The Sixth Circuit set aside the convictions for lack of notice to the public that 242 covers simple or sexual assault crimes. They employed the wrong standard for determining whether or not the particular conduct fell within the criminal liability range of 242. General language prohibiting the deprivation of any right. Oh, you can't see this. Can you see this? Yeah, you can. All right. Move it over to this screen just so I can see it. The touchstone is whether the statute, either standing alone or as construed by the court, made it reasonably clear at the time of the charged conduct that the conduct was criminal. So that's the touchstone. It has to be something that's clearly criminal. Was the court making a ruling on that case clearly criminal? No, it wasn't. So, but even it, like, I'm just saying, like, I have never seen a judge charged with a crime for making a judgment. There is already a remedy for that. And the remedy for that is appeal. And as we saw, Chile appealed and Chile won. That's the remedy. So anyway, that's all I got for today. I have, like Aaron suggested, thank you, Aaron. I do have chores to do today. You've probably been hearing that of the sprinklers. It is time for me to change them. My alarm went off several minutes ago. And so thank you for watching. Long story short is I like Jeff Gray. I am hopeful that he just made a mistake and wasn't intentionally misleading anybody in his Fifth Amendment analysis. That's my hope. I'm not saying that's true or false, but that's my hope. I dislike Michael Eline. He's a stupid, retarded piece of shit. And he misleads people intentionally. Or he's really stupid and incompetent as an attorney, or a combination thereof. So I hope I've made it clear. Thanks for watching, and have a great day.